Hey there, this is Douglas Smith. I am broker owner of DHS Realty. And today I just wanted to go over the 1 to 4 family contract in a simple, easy to understand way. This is the contract that we use on a single duplex, triplex, quadplex, or townhome. And I always like to relate it to anything that you buy in life. So anything that you were going to buy in life, you'd have a buyer and a seller. That's paragraph 1. You get the seller from the tax roll, and I usually like to write the buyer's name from the pre-approval letter. Paragraph 2 is what you're buying and what you're selling. So it's going to be the legal description of the property. Usually it's a lot and block, a subdivision, county, city, the physical address and the zip code. Paragraph 2, D delta, you would put any exclusions that the seller wants to take with them. And then paragraph 2E, by default, it has that mineral rights conveyed to the buyer. So if you were with the seller and they wanted to exclude some mineral rights, they would use a mineral right reservation. Moving on to paragraph 3, always 3A plus 3B equals 3C. 3B boy is the sum of all financing. Obviously, to fill that out, you need the buyer to get pre-approved so that you know the correct down payment and the correct loan to value. And once you add the down payment and the loan to value, you'll get the offer price that will end up being the sales price at some point if the contract's accepted. But always remember that 3A plus 3B equals 3C. 3A is the down payment, 3B is the loan amount, 3C is the offer price. Moving on to paragraph 4, I just like to dumb it down and say it's leases of people and things. Leases of people would be if there was a tenant currently in the property in a long-term lease. The borrower, the buyer, would need a copy of those documents and probably the transfer of security deposits and things like that, keys, garage door openers at closing. So that would be in paragraph 4. If there was any leases of solar panels or any kind of smart devices that went with the house, not the person, those would have to be disclosed, and there would be some addendums appropriate for that. Moving on to paragraph 5. Paragraph 5 is going to be the earnest, option, and the title company. So let's cover one at a time. Title company is generally negotiable. A lot of times it's whoever pays the title policy, but it's a negotiable item. It's a blank in the contract, and a blank means that it's negotiable. Title policy, I usually, if I was with the buyer, would find out if the seller agent has a particular title company they would like to use, and usually it's not a battle that you want to, die on a hill on. So you probably acquiesce on that. Earnest and option, those are also negotiable. The earnest money is applied towards the down payment of the buyer, and the option is applied as a credit towards the sales price. Those checks are negotiable, and you don't even have to write any of either of those, but most of the time you're going to have earnest and option. Earnest is really just good faith. It could be anywhere from 1 to 3% of the offer price or more. And the option is really a negotiable item as well. It could be $100, $50, $1,000, $2,000, $3,000, and the number of days is always a blank, so it's negotiable as well. Both checks are generally wired to the title company, and that wire needs to be at the title company 3 days from the effective date of the contract at midnight. And the effective date of the contract will be in the contract, dated. That's the day that the buyer and the seller have no changes whatsoever, and they've agreed to all the changes and initialed all changes. And that would be the effective date, also called the executed date. That would be day 0, and then you'd count the next day, 1, 2, 3 at midnight. And both of those monies, the earnest and the option, need to be delivered to the title company. And again, the earnest money would be applied as a credit towards the buyer's down payment, and the option is credited towards the sales price. Going down into paragraph 6, that's what the title company does. They do title and survey work. So the title policy goes back to sovereignty of soil, which is right around 1845 in Texas, and it checks for any liens, any paperwork, all the written history of the property, as well as all the owners of the property to today. And a title policy is issued to the buyer, the borrower, that insures the borrower from any claims up to the sales price. And that's negotiable who pays the title policy. It's generally about 1%. It's a little less than that, but that's a good rule to use. You always be safe. So when anybody asks how much the title policy is, just say ballpark, it's about 1% of the sales price. It's actually a little less. The big thing on the title policy is the one big thing it doesn't cover is shortages in survey. So if there's any kind of discrepancy or a surveyor screws up on a survey, you do want to get a separate insurance. And I usually have the buyer pay that. It's usually $80 to $130, and that's in the contract. And then, of course, the survey. The survey is addressed. And a lot of times the seller has their existing survey. If not, the buyer pays their own. And that's all addressed in paragraph 6. Also, paragraph 6 states that the home either does or does not have an HOA, which today is called a property owner association. But HOA and POA are synonyms. So be sure to check mark either box, whichever one's appropriate for the property. And then we move into chapter 7. We move on to paragraph 7. Paragraph 7 is going to be the property condition. And basically, paragraph 7A, it tells you that the buyer can get a home inspection done at reasonable times by a licensed TREC inspector or someone otherwise permitted by law to do such inspections. So that could be a plumber, electrician, roofer, things like that. And 7B boy talks about the seller's disclosure. So either the buyer has the seller's disclosure when they write the offer up, or the buyer doesn't have the seller's disclosure when they write the offer up, and they're given a number of days to get it, the seller is, to get the disclosure to the buyer. Upon receipt of the seller's disclosure, if it's marked in 7B boy, number 2, if the seller's disclosure is not given to the buyer when they write the offer, the day the buyer does get the seller's disclosure, that day is day 0, and they have 7 days to midnight to terminate for any reason or no reason at all. And then the third box is if there's not a seller's disclosure needed, which there's 11 exceptions. The two main ones are if you and I co-owned a property together and I was going to sell it to you, we wouldn't need a seller's disclosure. The other big one is a new home builder, a new home never lived in previously. That's an exception. And then there's 9 others. And they have to do with like foreclosures, tax estates, estate sales, things like that, where basically the seller wouldn't have the knowledge of the property, so they're exempt. And then in paragraph 7, it also talks about how these contracts are as is. So you really don't need to write any check to buy a home, much less you don't really need a price. Love and affection is a good enough consideration for property. But most of the time, you're going to have a price, you're going to have earnest money and option. And at the end of the day, if you do not write an option, which is a right to terminate, then these contracts are as is. And they're really as is, period. It's just the buyer has a right to terminate for a certain number of days if that's a negotiable item that's accepted by both parties. After you get through paragraph 7, you get into paragraph 8. And paragraph 8, I always like to say, is for CPS. If you're going to call CPS, it's usually a child that calls on a parent or a spouse. So if you ever have CPS called, it's usually a child that calls on a parent or a spouse. And that's what you have to disclose a relationship with in paragraph 8, as well as if you have a 10% share in an entity that's buying the property or selling it, or if you yourself as an agent are buying and selling. Paragraph 9 is the closing date. That's pretty basic. You click on the blank and, that's a negotiable item between the buyer, the seller, and I would usually get in touch with the lender and the title company, make sure they can also hit that close date. Moving on to paragraph 10. Paragraph 10 is whether the seller is going to stay in the house before closing, or if the buyer is going to stay in the house before closing. So if the seller stays in after closing, that's called a seller's temporary lease. If the buyer stays in before closing, that's called a seller's temporary lease. Those are short-term leases and therefore 90 days. So up to 90 days before closing, a buyer's temporary lease. Up to 90 days after closing, a seller's temporary lease. And there's an appropriate check mark to mark in that paragraph. And so again, that's paragraph 10. Most of the time, it's going to be possibly closing and funding or seller's temporary lease. So you'll mark one of those two boxes. Once you get to through paragraph 9, which is closing, paragraph 10, which is possession, you're in paragraph 11. At our brokerage firm, DHS Realty, we don't believe in putting anything in that paragraph. We like to leave it blank because we're not lawyers, and Generally, the only thing you put in there is a business detail or a fact that's not otherwise in a TREC promulgated form. So, if you wanted to pull the apple tree in the bag before you move in, have the seller do that, you could put that in there. But you don't want to use words like time is of the essence, or really, I like to stay away from that paragraph, period. We leave it blank. But that's paragraph 11. You only put a business detail or fact in there that is not otherwise on a promulgated form by the Texas Real Estate Commission. And then you get to paragraph 12, and paragraph 12 has a $sign in it. The sentence prior to it says seller to pay buyer's closing costs not to exceed blank amount. That blank amount, I always like to get from the lender, so that the lender, the buyer's borrower, the buyer's lender, the buyer's lender is going to tell you how much money to put in that paragraph. So if the lender says $5,200, that's what you're asking the seller to pay for the buyer, then you put $5,200 in there. If you're not asking for any closing costs, you put 0 in there. And that's paragraph 12. Really, from paragraph 12, I like to skip all the way to 21. And just like the Cowboys in the 90s with Dion and Zeke Elliott in this time frame, though they both wore 21, Deion Sanders and Zeke Elliott. And I always like to say that when 21 catches the ball, he puts the world on notice because he couldn't make a touchdown. And so paragraph 21 is notices to buyer and seller. And that's where you want to put the buyer's address, their email, their phone. I always like to also copy my email in there. And then the other agent puts that contact information for the seller. After paragraph 21, you get into paragraph 22, which is where there's some pre-stated addendums that you might use. Then there's an area where you can check mark other in paragraph 22 and type in addendums that aren't pre-printed there. But that's where you're going to attach the addendums that are going to be with your offer. And then, of course, there's signature line. And right before the signature line, it does state that if the buyer wants to have an attorney review it, they should do it before signing. You would physically give the contract to the buyer and have them drive it to the attorney, get it reviewed, have him drive it back to you, and then you would scan it to the other agent. But you'd never scan the contract into an attorney's office for client privilege. So that's kind of the contract in a nutshell. And again, one of the benefits here at DHS Realty is I basically just cover that whole contract under 15 minutes. And also I'd love to to look at all the contracts before they're sent out. And I do everything on my phone, so never even use a laptop, and up till midnight and wake up at 5 a.m. So y'all go get some, y'all grind, y'all hustle. Remember, just like Steve Jobs said, that live every day like it's going to be your last, because most certainly one day it will be. Y'all be safe and go get some.